All right, we're good.
All right. We're here to present Winkelman versus Parma City School District. So the plaintiff of the case are Jeff and Sandy Winkelman, and they are the parents of 6-year-old Jacob. Jacob has autism spectrum disorder, which is covered under IDEA. Jacob was attending Pleasant Valley Elementary School in Parma, Ohio, and his parents were active participants in the development of his IEP with the school district. While developing Jacob's IEP, an agreement cannot be reached between the school district and the parents about its contents under IDEA. So the Winkelmans filed a complaint citing that the school had failed to provide their son with FAPE. Since the IEP team could not reach a resolution, Jacob's parents decided to remove him from the elementary school and place him in a private school where they paid tuition out of pocket. So this case eventually reached the Supreme Court, and four things that the Winkelmans asked the Supreme Court's opinion on within the case are: did Jacob receive a FAPE in his original IEP meeting? Did the school district have procedural errors during the IEP meeting that resulted in a lack of FAPE? Can the parents receive reimbursement for private school tuition from rejecting the IEP that they deemed did not meet FAPE? And can parents who are not attorneys represent their child in court in regards to IDE litigation? Because during their court case, they did not hire attorneys, and so they were interpreting information from IDEA in their own way and trying to represent their son in court.
So the early decision on Winkelman versus Parma City Court is the court granted defendant judgment on the pleadings. The Sixth Circuit dismissed Winkelman's appeal because they did not have an attorney. The IDEA does not abrogate the common law rule prohibiting non-loyal lawyer parents from representing minor children. The IDEA does not allow non-lawyer parents to proceed pro se in federal court. The timeline: on October 27th, 2006, Winkelmans petitioned a federal district court for reimbursement of placing their son in a private school. On February 27, 2007, the case was dismissed because they did not have a lawyer. They argued that the IDEA did not prevent the parents from speaking on behalf of the child. On May 21st, 2007, this decision was overturned and the parents were allowed to represent his case in court.
All right, for the final holding and rationale, in a unanimous decision, the Supreme Court held that non-attorney parents have the right to represent their child with a disability in the IDEA administrative proceedings. The court stated that parents are given rights and protections under IDEA, including the right to present their own case without being required to hire an attorney. However, the court did not explicitly address the issue of whether non-attorney parents have the right to represent their child in federal court. Instead, the court remanded that decision back to the lower courts for further consideration. Therefore, the final holding on that particular issue was not definitively settled in the Winkelman case. Reflection. So Winkelman versus Parma City School District was a landmark case that highlighted the importance of parental advocacy in the education of children with disabilities. The Supreme Court's unanimous decision to uphold the rights of non-attorney parents to represent their child in the IDEA administrative proceedings was a significant victory for families seeking to ensure appropriate educational services for their children. The case emphasized the central role parents play in advocating for their child's rights. By allowing non-attorney parents to represent their children in IDEA administrative proceedings, the court recognized that parents possess valuable insights into their child's unique circumstances and can effectively advocate for their rights without the need for legal representation. Reflection continued. Overall, Winkelman versus Parma City School District stands as an important reminder of the significance of parental involvement and advocacy in securing the educational rights of children with disabilities. It reinforces the idea that parents are essential partners in the educational journey of their children and should be empowered to advocate on their behalf to ensure equal access to quality education.
So implications for the field, overall, no matter what the ended decision was in this case, the case that has an implication in the special education field, because no matter what the ruling was, educators are still obligated to give every child free, appropriate public education. The case obviously does make it evident that parents, before this case, IDEA did not protect them without a lawyer or being non-lawyered parents. But because of the ruling of the Supreme Court, they ended up getting protection in that case. And as said before, parents are a big part and critical to all children being given free, appropriate public education. Overall, educators should be doing their best to meet the needs of all students and finding the best accommodations to help them be successful in school.
And this is just our references to show where we got our information.